The other thing that is new is that we keep rolling out pieces of technology as we develop them and as we test them. We take an incremental approach to this. And this, what you're looking at now, is an application form, the application form for somebody who's filing a CRT dispute. And I promise I won't bore you by going through the forms too much, except I am particularly proud of this one because we designed this form by getting members of the public who had had a past strata dispute to fill it out and tell us what they thought and let us interview them about what works and doesn't work. And I can tell you that's really we're the only tribunal or court that I'm aware of in the world that has ever designed their application form this way. Typically court forms are designed by court administrators and they put there what they need, what information they need, and that's it. But as a result of this, we have a very easy to use plain language tool for people, and we don't get a lot of confusion about the form. So that's the form that you'd fill out if you need to file a claim. I did want to highlight some of the ways that we're trying to reduce barriers for people who sometimes have difficulty accessing the justice system. We do ask people optionally when they're filling out the form whether they have physical or mental or literacy issues that would require some special accommodation. So you probably can't see this at the back, but the form is asking if somebody has difficulty reading or writing, they have a visual or hearing impairment, they have a mental health issue. They don't have to give us this information and it doesn't go to any other party. But for example, if somebody indicates they have a visual impairment, one of our staff members will call them and ask them what we can do to make the process easier. And often that's something really simple like holding the mediation through telephone or having an oral hearing rather than relying so much on written documentation. And it might be the opposite for somebody who has a hearing impairment. So this has gone quite a long way actually in terms of trying to make sure that people feel included in the process, but it's just one of the things that we do on that score. As I mentioned, the other thing that's new is we recently were given jurisdiction over small claims $5,000 and under in BC. That amount will slowly go up to $25,000. And so we're really only about 4 months into this. So far so good. We've had a lot of these claims, about 2,000 of them in the last 4 months. And there are a couple of ways that this affects strata. Recovering bylaw fines you could already do under the strata jurisdiction we had. But what you might see happen, or some of the ways that we might see our small claims jurisdiction being used by strata folks, is that because the relationship between a strata corporation and a property management company is a contract relationship, and because contract matters fall within our small claims jurisdiction, it's conceivable that disputes between property management companies and strata corporations, if they're under $5,000, would come to the CRT. And similarly, claims can be made by strata corporations, by or against strata corporations, with respect to other service providers as well, including restoration companies, for example, maintenance companies, and that kind of thing. So that's something to bear in mind. That 4 months ago, before we had this jurisdiction, you would have to go to the BC Provincial Court for these matters. And I don't think I mentioned this from the outset, but before the CRT existed, so before July 13, 2016, for all of the claims within our jurisdiction now, you had to go to the BC Supreme Court, which some of you know is a pretty onerous thing to do over the collection of some bylaw fines or the enforcement of a bylaw. Another thing that's new is that we've recently rolled out a negotiation platform. So what this is a virtual neutral space where parties can go after they've filed a claim. So you filed a claim, you've served it on the respondent has come into the process. At that point, the claim is moved into what we call a negotiation phase, where the parties are invited to go to this neutral virtual space, which I'll show you in a moment, to try and just start talking to each other. And oftentimes, people can reach an agreement where they know that the next step is going to be spending more time and money on the claim. So this is what that looks like. Again, tough to see at the back, but I understand Sean might send out these slides after. It's meant to just sort of look like a chat room, people just to start talking. And if people can reach an agreement, they can hit a button and a mediator will come in and formalize that agreement. If people reach an agreement in the negotiation phase, we waive the fee for turning it into an order. So that's a bit of an incentive to do this at an early stage if you can. It also stops the disagreement from becoming a bit more entrenched. Just briefly, again, the next step is facilitation. That's really dependent on the parties and their jobs and their situations. So if two people are in a dispute and one is a single parent who has a day job, they can work on their dispute after their kids are in bed. And if they're in a dispute with somebody who's a shift worker and has a different schedule, that's okay, because that person can also work on the dispute when it's convenient for them. So the facilitation phase is really geared towards meeting the needs of the parties where they are.